The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Thank you. Please be seated. Now turn to the third case on this morning's docket. That is case number 103855, State of Kansas v. Sean Byrd.
May it please the Court, I'm Janine Cox, Deputy Appellate Defender. I represent Mr. Byrd, the appellee in this matter. Your Honor, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
This is a state's appeal where the district court granted Mr. Byrd a departure sentence from the guidelines grid box of 37 to 42 months down to 24 months. The court found the nature of the crime, the nature of the harm, the safety to the public, issues of non-injury, acceptance of responsibility on the part of Mr. Byrd as factors to consider for the departure. The court then sentenced Mr. Byrd to 24 months in prison. Mr. Byrd had at the time been in custody for, I believe, nearly 18 months. So he had a fair amount of jail credit toward his sentence. The state appealed, and the Court of Appeals, without oral argument, it was on summary calendar, found that the trial court factual findings were not supported by the evidence and did not establish a substantial and compelling reason for departure. The court vacated the sentence and remanded for resentencing, and we filed a petition for review, and this court granted that petition. The district court had the case gone back to resentencing at that point, or if it goes back for resentencing now, the district court's required to impose the presumptive sentence or to state on the record further reasons for the departure. We're at the point where Mr. Byrd has, in fact, finished his sentence and was released and completely discharged from Department of Corrections in February of 2011. The Court of Appeals opinion was in December of 2010, so that's kind of the time frame of where we are with the case.
He served the sentence that was imposed by the district court,
He
correct?
has served the 24 months, much of which he got in jail time credit because he was in custody for at least, I believe, 18 months prior to that sentencing. So he's completely discharged, no post-release or anything at this point.
Have you and your client discussed the possibility of withdrawing his petition for review?
I'm sorry?
Have you and your client, which I guess I can't ask you what you've said to each other, but have you considered, counsel, the possibility of withdrawing?
The petition itself came prior, of course, to his discharge.
Right.
The determination, it appears to me that the determination of what happens if it goes back is the same regardless of whether we do it now or we did it then. I mean, the district court's determination still will be whether there are additional findings, whether the court makes additional findings. The harm to my client is no different now than it would be then.
Because you're saying he can't be sentenced to the full non-departure term because of the discharge?
No, I'm not saying that. And I've had this conversation with the court before on another case, and that there are cases where people who have been completely finished with a sentence that was imposed have been resentenced and served additional time. But that would have occurred regardless of whether the petition was taken or not taken. He would have gone back for resentencing. Now, right. The question is, would it have been better? I suspect the question is, would it have been better to have been resentenced then and now be done with it than to still have it here now? But in terms of what happens, it's the same procedure.
Right.
I
understand. The status quo didn't benefit him.
I'm sorry?
The status quo before the petition for review didn't benefit him.
That's right. Because there is the potential on the petition for review, at least I hope when it comes, I have potential to be successful.
Yeah.
And if that's the case, then we get the relief we wanted, or we stay where we are and he's discharged.
Okay.
Does that answer the question?
Yeah, I was backwards. Thank you.
Okay. The question here is whether the court found proper factors to grant the departure. And as this court's aware, there's a two-part test in a sentencing departure case. That test is an evidentiary test first to determine whether or not there's support in the record for the departure factors. That's simply an evidentiary test. And then the second part of the test is a legal test to determine whether or not the reliance on those factors is sufficient to support the departure from the presumptive sentence. And in this case, the court found, and we will readily admit that there was some confusion in the court because he was being sentenced on crimes from two separate events. The crime that the presumptive sentence was departed from was on the possession of cocaine, to which he pled. The other crimes that he was being sentenced for at the same time had to do with, not in this case, but had to do with robbery charges where he was convicted by a jury of lesser included offense and a criminal threat. The question that the state raised was whether or not the judge actually imposed the presumptive or the departure sentence based on factors that went to the other crimes rather than to the possession of cocaine charge. And that's what the Court of Appeals determined and rather focused its opinion on whether or not you could use factors from one case that seemed to apply to one case or one set of crimes and convictions to depart on another crime of conviction in the same sentencing case. My argument is that I don't think that's not the question that has to be answered. I think the question that has to be answered is whether, regardless of whether it appeared there might be some confusion, whether any of the factors that the judge articulated were substantial and supported by the evidence. And my argument is that they were. The statutory factors, they're statutory and non-statutory factors. They're considered the same. They're reviewed the same. Nothing more is required of one than the other in order to hold weight. There was testimony. The judge articulated a degree of less of a degree of harm. Does that apply to possession of cocaine? In this case, as the court will remember, the cocaine was all residue. It was not like there were baggies and baggies of cocaine present. We would argue that there was a lesser degree of harm, and that statutory factor could be used as a factor to depart.
Ms. Cox, in your rendition of the analysis, you've broken it into two steps, the evidentiary and the legal.
Yes.
Where in that equation does the necessity of findings of fact fall? I mean, I think we could agree that there is evidence in the record to support your argument that this was residue. But where is a finding of fact by the trial court to that effect and finding of fact that the harm in this cocaine case was less than typical? Do we need that?
I have to look. I'd have to look at the transcript to see specifically. I've got it outlined, and I can pull that up now, or I can bring it back up on rebuttal. What the court actually said. I am fairly certain, just from my memory here, that the court didn't say because this was residue of cocaine, there was less harm.
No,
I'm pretty sure that wasn't said.
The findings of fact would be the things that have to have substantial competent evidence, though.
I'm sorry.
As far as where it fits in the analysis, it's the findings of fact, required findings of fact,
right,
that would have to be supported by the substantial competent evidence. It's a part of that evidentiary standard of review that you mentioned. It's just that I think Justice Lugar's saying, but where are the findings of fact, the required findings of fact here?
In terms of the court actually articulating A, B, C, an actual factual statement, I think my recollection of the record is that's probably not there. What the court did articulate were the categories of what he was finding, and of course then what I did was, in reading the transcript, find the evidence that I believe supported those.
Is that fatal to your argument, that we don't have that? And if not, why not?
I don't think it's fatal to my argument. I may be. I need to look at the transcript again before I say this exactly. But I believe that the judge's statement about what things he relied on, even though he didn't state them in specifics, but rather in categories, I think is still sufficient. I don't think that it's required that, I suppose you could say something that's required that the court say something as specific as he has a family that supports him, or we're talking non-statutory factors here, or he took responsibility. But if he names the general category and then the facts are in the record to support that, I think that's sufficient. That's my argument, that would be sufficient. And I cited in the brief, the blue brief, several places in the record, volume 4, where Mr. Byrd did accept responsibility for the things he had done, and although it's not necessary for all of those things to tie to a specific factor, I believe if you look at, and I cited a string cite of cases where it was clear that the court was discussing with Mr. Byrd things that had happened and why they had happened and what he had done and what he had not done, and I think it's fairly clear that there's sufficient evidence of the record for that non-statutory factor. The Court of Appeals, in its opinion on page 5, reframed the issue. The issue, as was framed, was that there wasn't substantial competent evidence and there were not substantial and compelling reasons to depart. But the court reframed the issue as whether it's permissible for the sentencing court to consider mitigating factors not related to the crime of conviction, but related to other crimes when sentencing the defendant for the crime and other crimes at the same sentencing hearing. And that's what they answered in the negative. That's how the Court of Appeals reframed the question. I don't think that's the question that needs to be answered. I believe the answer is just the simple answer of whether there was support in the record for what the judge said, although be it not as well articulated as possible, and then whether those were substantial reasons for the departure from the presumptive sentence. I see that I'm out of time. I would argue that the trial court made the proper findings, that the factors were well enough articulated and supported by evidence in the record, and that the Kansas Court of Appeals decision should be reversed and the district court's imposition of the departure sentence affirmed.
Why did the Court of Appeals get it wrong when they concluded that nature of the crime doesn't fit with the crime of cocaine? Page 7 in their opinion. And then I would ask the same question about why they got it wrong when they said acceptance of responsibility is inconsistent with the Sentencing Guideline Act in general.
Well, the nature of the crime, and I think I raised this in my petition, in my prayer for review, is the nature of the crime is a residue rather than, or at least I would frame it as a residue of the cocaine rather than, as I said, baggies of cocaine. So the nature of the crime is somewhat different than what we'd ordinarily think of a possession crime. And the acceptance of responsibility, I'm not sure whether reading down the list I can tie that right into the guidelines, but clearly the acceptance of responsibility is a viable sentencing factor in just virtually every court that in the federal system, it's you get a departure. You get a couple of steps taken off if you accept responsibility. Clearly, there's case law in this state where acceptance of responsibility is referred to. I've had cases where that's certainly been considered as a factor. I don't know and that's a non-statutory factor. I'm not sure that if that non-statutory factor is as broad as I think it is, which is pretty much anything can come in under that I have to be able to tie every single thing to the stated purposes of the guidelines.
Well,
I don't think that's my burden.
I don't understand why acceptance of responsibility is uniquely applicable to the cocaine here rather than the other charges, because he went to trial on the robbery criminal threat and he pled to the cocaine, so he absolved the state of Kansas of the responsibility of having to try him and the
Correct.
expense and the risk of trying him. So, I mean, when you plead to something, that's accepting responsibility.
I agree.
Okay.
Is there a question there about
Well,
why I think? Are you asking me if I'm double counting that?
Well, I didn't understand why you were ambivalent about accepting responsibility being applicable to the cocaine charge.
I'm not ambivalent about it. I'm not ambivalent about it. I think it perfectly applies, and I think it applies in virtually every case and in every judicial system. That I'm not ambivalent about it at all. I think that's exactly what he did here. And if you read the record and read his discussion with the court, he clearly comes back again and again to his his past inability to stay away from substances and substance abuse.
Any more questions of counsel? Thank you, counsel.
Thank you, Your Honors.
Yeah, please, the court. Ellen Mitchell, Saline County Attorney, on behalf of the state of Kansas. I want to start by just clarifying that there's really almost three separate events that happened here. There was the robbery at the Little Dillon store on Iron, where money was taken from the clerk. There was a separate, unrelated, on a different date, robbery at lunchtime at Taco John's, where the state contended it was a robbery. The jury found it to be a theft. And it was busy in Taco John's, and as the defendant took off from the restaurant, someone followed him. That person was threatened, and therefore the criminal threat charge. And then subsequently the police located the defendant, searched his home, and found cocaine, methamphetamine, paraphernalia, and marijuana. And the robbery theft at Dillon's was charged in one case, and in the second case that occurred on the same day, the Taco John's, they fled, followed him, and found the drugs in home, were charged in the second case. The defendant filed a motion to sever in the second case, and the court, rightfully so, granted that severance and said, you are trying the robbery criminal threat case at Taco John's, and will sever the drug cases for a trial at a later date. So technically, or realistically, factually, there's probably three separate events that we're looking at. The defendant came before the court after conviction at time of sentencing, and interestingly enough, in his request for departure, he said, give me probation. If you don't, I'd like to have time served, or in the alternative to time served, I'd like everything to be run concurrent in both cases for controlling sentence of 40 months. And the state stood up and said, we'd like everything to pretty much run consecutively, with the exception of, I think, a misdemeanor sentence, the battery and the theft at Dillon's. And we'd like to apply the time there that he's already served and get him on his way to finish off his sentence at prison and not have him come back. And the court didn't do what the state requested either. Instead, the court, I think, got sidetracked by the facts of the case and began discussing the Taco John's incident and entered a controlling sentence of the 24 months, which was a departure on the cocaine. Remember, the cocaine, the court had previously found, was a separate, almost unrelated event that had to be tried separately. and then began to use the facts from the Taco John's case to justify the departure in the drug case.
But we have non-exclusive factors,
Correct.
and we have approved the consideration of amenability to probation, culpability, relative culpability. The court is sentencing on all of the cases here at the same time. What really difference does it make if the court is looking at this individual, all the accounts upon which it's sentencing, where it allocates the departure?
Had the court looked at the Taco John's incident and made said all the things that it said when talking about the criminal threat, which had a different victim than the theft conviction, but it was the same incident, and made those findings, the state wouldn't be here today, because those two crimes were connected in part.
Why didn't the state correct if the district court was confused, why didn't the state correct the district court at the time?
Because the state didn't think for 1 minute that the court was going to grant the departure that it did, and run everything concurrent and give him a durational departure.
Isn't that why you're here? You just disagreed that there was a departure. I mean, it strikes me strange that you're here kind of on this.
Because,
we deal with technical aspects of this, but you just didn't like this departure. Isn't that why we're here? I mean, you just said
correct,
so.
For a lot of reasons, and one is we felt that the judge should have had the judge addressed, or the state felt that didn't feel that the judge had addressed the cocaine charge, that it didn't give any reasons, and that's what it is. It didn't want that to become a precedent.
And as Justice Johnson pointed out, I mean, this is a multiple case sentencing. They're all put together. There's one departure motion filed for all the cases, as I understand it. Kind of repetitive.
Had it been
how specific? I mean, basically, what you're saying is that on each count, on each sentence, the court needs to specify which departure factor,
or on the controlling sentence, because the judge didn't depart on the criminal threat or the Taco John's incident. It departed on the drug case, right, in which it made no findings. Had the court had they convicted of robbery instead of theft, and he came in and made these findings and ran everything concurrent, I wouldn't be here. The state wouldn't be here under those circumstances.
Ms. Mitchell?
Yes.
I think if the defendant had a complaint about the legal basis of a sentence, we would expect the defendant to object at the time, or attempt to call it to the trial judge's attention or sentencing judge's attention. Should we not expect the same thing of the state?
Once the judge pronounces a sentence, does the state have the right to stand up and say, "Judge, you're wrong," and the judge can't change their sentence once it comes out of his mouth? What good does it do then? In fact, a judge probably wouldn't appreciate if I stood up and said, "I disagree with you and you haven't done this." I would, it would be disrespectful to the court to stand up. I could have made those arguments to the court after the defense.
What about the findings? Don't we say that you have to object to the insufficiency of the findings? I mean, even if you can't change the court's pronouncement of the sentence, you certainly can say, under our rule.
Should I have filed in a motion to come back and said, "Judge, after review, you've made insufficient findings"? I still don't think the judge can change their sentence.
I'm talking about legal error,
right?
Not disagreement.
Disagreeing with the facts, right?
And I think that's what my colleague is trying to get across too. Would it have been inappropriate or disrespectful in your view to just stand up at the end and say, "Judge, you want to put some findings on the record to support that"? Or, I mean, it seems to me that if you're seeing legal error, you have a right to say something about that.
That's
try
correct.
And rescue the court from himself or herself.
Correct.
Okay.
It has been the, I guess it's pretty clear what the state's contention is. Justice Johnson pointed out that entering the plea might be accepting responsibility, but when you review what the defendant said at the time of sentencing, his attorney said, "You don't deny responsibility," and the answer was "no doubt." And again, the state feels that that really isn't an acceptance of responsibility when you come in and say, you don't deny responsibility, no doubt. He didn't come in and say, I am so sorry, and this is what it is. And I didn't feel like the state didn't feel like the defendants, the factual statements there constituted accepting responsibility. In fact, he blames it on everything. And when my brother was 8 years old, he fell off a ladder and died, and I had to carry him in my arms to my home. And my mom died when I was 13, and she died in my arms. And then my dad died. And then my girlfriend suffered 2 miscarriages within 6 to 8 weeks. And he didn't come in and say, I have a drug problem and I needed money, and I grabbed the money out of the cash register at Dillon's and I grabbed the money out of Taco John's.
Do you disagree then with the legal conclusion that the Court of Appeals reached that acceptance of responsibility is not a valid departure factor under the sentencing guidelines?
Under the facts of this case.
That's not what they
But you're right.
Yeah, they make a broader statement though, and I take it you're not agreeing with what they say.
I think acceptance of responsibility is a proper consideration for the court.
You would just distinguish it on the facts of this case don't support that departure finding.
Correct. Does anyone have other questions?
More questions of counsel? Do you have any further presentation?
No, thank you.
Thank you, counsel. We'd reserve 3 minutes for rebuttal.
Just one brief point. I think if you read the transcript, and that's volume 4 and it's not very long, but I think there are several points in here where Mr. Byrd does admit that he's made bad choices and that he's the one responsible. There's one on page 28. There's another one, maybe it's shortly after the
Is this
judge.
at the sentencing, you're saying?
I'm sorry?
Is this at the sentencing you're talking about?
Yes, that's actually the only transcript that's in the record. And I think there's one after the trial court talks about his life could be a source of a Nashville lyric in a country music tale. I think that Mr. Byrd admits again that he's not made good choices. And I think that to require somebody to, fall on their sword or whatever to accept responsibility seems a bit harsh. Again, I would ask this court to reverse the Court of Appeals decision and affirm the trial court's imposition of the departure sentence. Thank you, Your Honor.
Any questions of counsel? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.